A durable power of attorney allows you to pick a trusted family member or friend who will take care of managing your money and other property if you become incapacitated. That is, you're unable to make your own rational and informed choices about your personal, legal, and financial affairs. Without a durable power of attorney, bank and investment accounts held in your name will become inaccessible. IRA distributions can't be requested, bills can't get paid, tax returns can't get filed, and real estate can't be bought or sold. Instead, a loved one may be forced into court, an emotionally and financially draining process, to be appointed as your legal guardian. And a judge will oversee the guardian's every move. The guardian not only has to manage your affairs, but annual reports to the court are required as well at additional financial cost. A durable power of attorney provides authority to handle your affairs without the court's involvement. Only by writing down things properly can you make sure that your wishes are honored and decisions are made the way you want. Even if you have a trust, you need a durable power of attorney. There are powers personal to you that a trust cannot grant a third person. For example, a trust cannot allow a third party to sue somebody on your behalf, like you were in a car accident. A revocable trust with a pour-over will protects your assets during your lifetime and beyond. Revocable means that you can change the terms of the trust, transfer property freely in and out, control the property fully, and even revoke it in total. Basically, you give your property to a trusted person to be managed for you or for somebody else. Person is in quotes because the courts have ruled that even when you transfer the property to yourself as trustee, you are a separate legal person. In the case of a revocable living trust used for probate and other planning, you are the grantor, trustee, and beneficiary of the trust. You own the trust and the trust owns the property. It may sound scary to transfer your property to somebody else, but remember, in most cases, a trust is set up to avoid probate and manage property during your lifetime. You often transfer the property to yourself as the trustee. Often, you as trustee own the property and you are the beneficiary and the grantor. You literally own nothing in your own name. The property is owned in your name as the trustee. When you have a revocable living trust, you literally own nothing. Your trust owns it all. But don't worry, because you are the trustee, you are in control, and you are also the beneficiary of the trust during your lifetime. So you stay in full control of all your assets. You can have the income, spend the money, buy, sell, and do anything you want with the property in the trust. In every practical sense, having a revocable living trust is almost identical to owning the property yourself. If you become unable to manage the property, you've already named somebody, your successor, to manage the property for you. The difference happens when you are gone. Since technically you didn't own the property, there is nothing to go to probate. Instead, your property and assets are quickly transferred to the new trustee and then distributed to your heirs without all the red tape and bureaucracy of probate. Your successor trustee does not have to get the approval of the courts. And if anything is missed, a pour-over will should have been created to move everything to the trust. Now, last will and testament usually requires probate, but with additional planning, you can get away with a last will and testament as a safety net. But a last will and testament is not a probate avoidance device. A last will and testament does not protect you during your lifetime. A will only goes into effect after you pass, and it requires a judge in probate to be validated and activated. A will is completely ineffective until probate. A will is the instrument of probate. Probate is required to make the will stand up and be followed. Courts and judges are required. Your will is like a letter to the court telling the court how you want your property distributed. Somebody must make sure that the will is proved to the court, that all your property is collected and appraised, and all your bills and taxes are paid before the property is distributed to your heirs. A judge must validate the will and appoint the person in charge of the estate. Only then is the will valid and in effect. Until then, it's just a piece of paper with no legal power. Wills are among the most contested legal documents in the United States. Today, it is common for unhappy relatives to challenge a will. This results in higher attorney fees and even more delays. It is not uncommon for a contest to be raised over trivial matters. It seems that some people just want to cause problems despite the fact it doesn't gain them much of anything. Wills encourage challenges over assets because a petition must be filed in court to probate them, which is like filing a lawsuit. As a result, since a lawsuit has already been filed to probate a will, the contesting party can simply file their claim without starting their own lawsuit. However, if your estate is straightforward, a will may be a good planning tool for distributing your remaining assets, but it needs to be done along with some additional planning.